Adultery, penalties, and premarital agreements. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Doug Stanley, ACTEC Fellow from St. Louis, Missouri. Does cheating in a marriage void a premarital agreement? What is an infidelity clause? ACTEC Fellow Professor Elizabeth Carter from Baton Rouge, Louisiana, explains what the adultery provisions are and are they enforceable? Welcome, Elizabeth.
Hi, thanks, Doug. So we often hear about these types of provisions with celebrities. So do people really have these, and are they enforceable? I should say at the outset that I'm a little bit biased here. I never recommend these types of provisions, but just like anyone else, I find them very interesting. So I'm going to cover three issues. Number one, what are adultery provisions or penalties? Number two, why do I usually advise against them? And number three, are they enforceable? So first, what is an adultery provision? Well, that's a provision in a premarital agreement or sometimes in a postmarital agreement that attaches some sort of financial penalty on a spouse who commits adultery. You can draft these provisions several different ways. The provision might be reciprocal, punishing each spouse equally in the event of adultery, or they might be one-sided. So, for example, one agreement that I've seen included a provision that said that if it was proven or stipulated that a divorce resulted from the infidelity of either spouse, then the non-offending party is entitled to a lump sum of $50,000. I always wonder how people come up with a value for these things, but they do. Sometimes the money is couched in terms of spousal support. So, for example, I've seen an agreement where the spouse has waived spousal support entirely, but then the next provision said that if the husband, who I presume is the wealthier spouse in that case, committed adultery, then he had to pay spousal support to the ex-wife equal to $40,000 a year for each year of the marriage, up to a maximum of $200,000. Some others will tie adultery to the division of assets at divorce, which is a similar idea. So that's what they are. Why do I not recommend them? Well, there are lots of reasons, but the most obvious one is that I believe that these provisions usually run counter to the entire purpose of a premarital agreement. When you decide to have a premarital agreement, one of your primary goals, presumably, is to set the rights of the parties in advance in an effort to avoid expensive, uncertain, and demoralizing litigation. The problem with adultery provisions is that they will tend to do the opposite. In many jurisdictions, it's unclear whether these provisions will be enforced, which I'll talk about in a minute. That uncertainty will obviously incentivize litigation. But even if you're in a jurisdiction that would clearly enforce the provision, the couple is likely going to dispute whether an act of adultery even occurred in the first place. And that opens you up for more amazingly embarrassing and demoralizing litigation. You might be surprised to learn that the terms adultery and infidelity are actually legal terms with a pretty rich legal history. That history has often been rooted in patriarchal notions about women and their sexuality. Even the concept of what specific sexual acts will constitute adultery for legal purposes is often rooted in sexist and patriarchal notions that viewed a wife's body and reproductive system as her husband's property. Some of that has changed, but you certainly see remnants of it today. So just know that when you use a term like adultery or infidelity in a contract, that's actually a legal term whose precise definition may not be entirely clear and probably does not align with an individual's more personalized views about sexual and emotional fidelity within their marriage. The third and final issue here, and perhaps the most important one, are these provisions enforceable? Well, maybe not. There are hardly any cases out there on the issue, so it's very difficult to say whether some sort of penalty provision for adultery will be enforced by a court. And like I said before, that really opens you up to litigation and litigating something that is very intimate, private, and embarrassing. A handful of courts have specifically refused to enforce these provisions on public policy grounds, but the cases are few and far between, and the rationale of those cases wouldn't stand up in all states. The general rule in most states is that spouses can enter into marriage contracts with respect to anything that is not prohibited by public policy. So, for example, Section 3 of the Uniform Premarital Agreements Act gives you a non-exclusive list of things that parties can include in a contract and specifically allows a couple to contract with respect to, quote, any other matter, including their personal rights and obligations, not in violation of public policy or statute imposing a criminal penalty. Louisiana, where I am, is similar. Louisiana Civil Code Article 2329 says that spouses can enter into a contract, quote, as to all matters that are not prohibited by public policy. So is adultery or fidelity a public policy issue? Well, it depends. In many states, adultery remains an independent basis for divorce. Even though these states have no-fault divorce, you can also obtain a divorce based on adultery. Adultery can also affect spousal support or property division in some states. Criminal statutes for a shocking number of states continue to exist for adultery. Even though these might not withstand constitutional scrutiny today, they're still on the books. And so in states like this, the states have clearly taken an anti-adultery stance, and penalty provisions could conceivably be enforceable. It seems clear that a prohibition on adultery or a penalty provision for adultery might not be counter to state public policy because state public policy itself takes an anti-adultery view. Other states, however, view no-fault divorce as the exclusive basis for divorce. So in some states, adultery really can't be considered at all for divorce purposes. It's not a basis for divorce. It's not a basis for awarding or denying spousal support. It's not a factor that can be considered for dividing property. So perhaps the public policy in those states suggests that adultery penalties are not enforceable. Well, California is one of those states with that type of no-fault stance. And there's a somewhat famous 2002 California appeals court case called Diosdado v. Diosdado, where the court refused to enforce an adultery provision in a post-nuptial agreement. The agreement was signed after the husband had had an affair. The agreement imposed a financial penalty if he did it again. And spoiler alert, he did it again. Well, the couple gets divorced, wife sues. Shockingly, husband now contests the enforceability of that provision. Well, ultimately, the California Appeals Court holds that the provision is unenforceable under California law because it ran contrary to public policy as set forth in California's no-fault divorce laws. But that rationale would not hold up in states that still permit adultery to be considered for any reason in a divorce. So the California case made it really clear that by enacting this no-fault divorce regime, California had made a public policy stance that any type of marital fault was just no longer relevant for divorce purposes. And in the view of the court, that extended to agreements reached by couples in matrimonial agreements. But that might not hold up even in other states with laws similar to California's. There's an unreported 2020 Hawaii case called Crawford v. Adachi, which specifically disagrees with the California case. The court there that said that although marital fault is not a basis upon which the courts could divide up marital property, that didn't preclude a couple from freely entering into an enforceable agreement to the contrary. So given the lack of definitive legislation or case law, The enforceability of these provisions around the country is an open question. I think it's always also a fair question to ask our clients if they're really adamant about one of these provisions, what their concern really is. Will money really heal you from the harm caused by the adultery? And if you're this concerned that your spouse is going to commit adultery, do you think the financial penalty is enough to prevent it? So these provisions are definitely interesting, but they're also generally inadvisable in my view because of the legal uncertainty regarding their enforceability. So a client who insists on one of these provisions is basically asking for litigation down the road.
Thank you, Elizabeth, for your insightful presentation.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review. Follow us on Facebook and Twitter at ACTEC Talk.